and members of the committee. For the record, Delegate Brian Crosby, here to present House Bill 128, Private Passenger Motor Vehicle Liability Insurance, Enhanced Underinsured Motorist Coverage Opt-out Option. This is a bill that passed in a bipartisan fashion out of the House last year. It was House Bill 266, and all it does is make a simple change in our policy from an opt-in to an opt-out. The best way to describe this bill is an example. So if I have $30,000 in coverage, and Rob here has $50,000 in coverage, and I hit Rob and am an at-fault driver, and there is $80,000 in damage, then what you would think is, typically, I have $30,000 in coverage, Rob has $50,000 in coverage, and so under the $80,000 in damage, that is fully covered. But you would actually be wrong. It's really an offset. So my $30,000 is credited against Rob's $50,000 policy, and Rob is then out $30,000 out of pocket, which is a pretty large expense. And the time that you recognize this is the time you're probably most in need, or, you know, it's a time where you've had or sustained a serious injury. So all this does is take it from an opt-in to the opt-out. Like I said, right now, the current take rate in Maryland is less than 1%. It's around 0.5%. And in 2017, when it came in front of this body to enact what is now dubbed as stacking, so the two policies stack on top of each other, we made the determination that stacking was a good policy. But for obvious reasons, frankly, because of education around the topic at the time you're signing up for your policy, you know, the take rate on this has been extraordinarily low. This puts it in line with PIP, and PIP basically covers lost wages and medical bills. And when you sign up for your auto insurance policy, you have to affirmatively select out of PIP. And this statute, or this change in the law, directly mirrors the PIP statute to make those two insurance options the exact same. I did this on my own policy 2 years ago, and I encourage everybody on the committee to do it. I have $300,000 in coverage, and my EUIM coverage or cost was $2.16 more per month. Additionally, when I looked at doubling my insurance and increasing it, which is in effect what this would do, it was significantly more. And so there will be you know, opponents to the bill, which will be all the insurance agencies. And some of the things that you will hear is that people don't take it because they're not educated on it. And that's why. And the first thing I would just respond to that with is this isn't a mandate. It's just still an option. So there will be more of a conversation if you have to opt out of it than if you were to opt into it, because most customers are going to say, is that the lowest my premium can go? And then at that time, I'm sure that the agent can brief he or she on their policy, and then it's a coverage that they will affirmatively opt out. The second is that this is going to somehow raise rates. It is not a mandate. Like I said, again, it is strictly an option. And I think that the policy behind this is that we would want less people to be stuck with larger bills or unexpected bills at the end of, you know, a significant car accident. And I think that that is good policy, because I don't think that most people have, in the example I gave, $30K laying around. And, you know, I think in the end, frankly, you know, the bottom line here is I think that there will be more claims, or financially more claims paid out if more people opted into this program. And I think that's really getting at the crux of the opposition. So with that being said, I urge a favorable report, and with your permission, Mr. Chair, I'd like my panel to go.
Good afternoon, Mr. Chairman, members of the committee. David Muncy, current president-elect of the Maryland Association for Justice. What this bill seeks to do is take what we passed in 2017 and make a more informed consumer. Currently, this coverage exists. People can purchase it But as Delegate Crosby explained, barely anybody has. Around 1% or less than that have actually bought the coverage. What the bill seeks to do is create an informed consumer. People will be given a waiver form that will say, this coverage costs X amount. If you don't want the coverage, you can opt out of it and you will save X amount. So they see what it costs and what it saves to not select it, and they make their decision. This is not a new process. We do the exact same thing with PIP coverage. The MIA approves the forms. One of the things that the insurance agency lobbyists are going to say is that it's very complicated to create these waivers and that it's going to invite litigation. That's simply not true because the MIA is in charge of approving these waivers. So they set a standard waiver, every carrier uses it. That's how it works in PIP. We've been doing this for many years in the state of Maryland. So the biggest thing is educating people that this is a coverage that is available and it will better protect them in the event of a serious collision that causes significant accident damages. The last thing I want you to think about is it won't just help the injured victim, it will also help everyone with a stake in the outcome, including Medicare, Medicaid, private health insurance, and doctors and hospitals, all of whom are paid back out of these settlements. It will create more coverage for these significant injury cases for those stakeholders. Thank you.
And before the next speaker goes, as you see, we are having a difficulty with our timer, so please be mindful of your time. Hopefully you guys have already planned your presentations to go under 2 minutes. Otherwise, I will do an untimely reminder. Thank you very much.
Thank you. Good afternoon, Mr. Chair, members of the committee. My name is Gwen Marie Davis, and I am the Secretary and Treasurer for the Maryland Association for Justice. I'm also a law firm owner in Prince George's County. I urge you to vote in favor of this bill. You heard what it is, but I'm going to explain to you why it's so important. Every day in my office, in my practice, I see injured victims in car crashes who would benefit from knowing and having the education of this bill. A lot of my clients think, okay, I've got $30,000. The person who was at fault had $30,000 in coverage. I can use that $30,000 to help me, right, with my medical bills and my lost wages and things like that. But I also have underinsured motorist coverage of $30,000 or $50,000. Can I use that too? Well, if you have $30,000 only in your underinsured motorist coverage, no, because you did not choose the enhanced underinsured motorist coverage, you cannot use that. And that's a really difficult conversation when someone's got a permanent injury and they're dealing with the effects of a long-term car crash. I have a client that testified here last year in this committee who was an NCAA coach who came home from a game, running a tournament, and was in great condition, came back, had a head-on collision with a drunk driver. Her life has never been the same again. She's got a traumatic brain injury. She's not able to function as well as she could have. And I had to have that hard conversation with her that unfortunately you are not able to use your $100,000 because you already got the policy limit with the other at-fault driver. So what do we do? That's a tough conversation. She actually called her insurance agent and said, hey, I've never heard of this. Can I please add it to my policy? They hadn't heard of it either, her particular agent. So it's something that, although it was passed in 2017, education must occur. So having the opt-out option is needed and necessary. Thank you.
Thank you. I believe our timer is working now for the next presentation. Thank you.
Thank you, Mr. Chair, members of the committee. It's my pleasure to be in front of you. I apologize I was a couple of minutes late getting here. My name is Bruce Plaxton. I'm a past president of the Maryland Association for Justice, and I'm a national officer of the American Association for Justice. My law firm handles primarily auto cases, and since this bill passed in 2017, we do about 500 cases a year. Over the 6 years, you could say there were 3,000 auto cases, and not one of my clients knew about this coverage. As a public policy, you passed this in 2017 and made it so that your constituents would be able to buy this. Unlike many states where they get this coverage automatically, this is just about transparency. I want to give you an example in the little time I have, that for years you pay premiums for life insurance. You pay premiums every year since you're a young person, and at some point, unfortunately, you pass away for whatever reason, and your spouse goes to collect $1 million worth of coverage. You've been paying these pricey premiums for years, and the carrier were to go to you and say, we're taking a credit for Medicare benefits that your spouse would have received. We're also going to take widow benefits or spousal benefits off, and it happened at work, so we're going to deduct all the workers' comp money that your spouse got. And you say, wait, I bought $1 million worth of coverage. You're entitled to $1 million worth of coverage. Our clients who bought $50 or $100 or $300,000 worth of coverage are entitled to that money. This is a hidden premium. Now, the argument that this is going to increase rates is specious because your constituents will have an opportunity to simply deny the coverage, simply reject it and say, no, I want my premiums to stay the same. Thank you for bringing it to my attention. That's all we're asking is for you to implement the policy, the public policy that you passed 6 years ago and give your constituents a chance to actually be informed. Thank you, Mr. Chair. Thank you, members of the committee.
Mr. Chair and members of the committee, Rob Gargiulo with Compass Advocacy on behalf of MAJ, speaking in favor of House Bill 128 as well. I think you understand the issue. I mean, this is something that the state made a decision on from a policy perspective in 2017. That's done. The dynamic is it's an opt-in. But I would argue, and I asked 10 friends over the weekend, if you pay for $50,000 in coverage, in the example that Delegate Crosby provided, do you think you're going to get the full 50, or do you think it'll be credited from someone else who injures you? And every one of them thought they would get the full 50. And so most consumers, your constituents, do not realize that they can take advantage of something that was allowed in Maryland in 2017. This is being done in Pennsylvania to varying degrees, much more broadly than what we're seeking in Maryland, Virginia. This is not a new thing. This has been around. What this bill does is it basically says, hey, just like PIP, you're going to get a piece of paper that basically says, and this is how it works and how it's worked in law for PIP coverage, you're going to get a piece of paper that says, this is what you'll get and this is what it'll cost. Do you not want to pay this amount? Sign here. So your constituents, drivers out there, they can make an educated decision, and that's what this is about. They can make an educated decision about, do they want to have a little bit higher premium for this benefit? Now, it's disappointing. Last year, the MIA provided testimony. I know they provided testimony again this year. It's nearly identical to last year, basically saying this is going to cost all kinds of money. And I will tell you that is absolutely incorrect. We're talking $2 to $5 a month. But at the end of the day, your constituents get to decide, do I want to do it? Delegate Crosby said he looked at it and it cost him $2.16. Look at yourself. The MIA, I think, is completely wrong on this. Lastly, the insurance agents and brokers cite the language as being impossible, virtually impossible to implement. The language in the bill, page 3 going on to page 4, is taken exactly from the PIP statute. If you look at the PIP statute, section 19506, subsection C, it's almost verbatim. So we're basically looking to do for this, for EUIM, what you can do for PIP. And with that, Mr. Chair, I would urge a favorable report.
Seeing no questions, move on with the next individual. You have another panel, Mr. Vice Chair, was that it? I apologize, I didn't see there was a question. Delegate Queen.
Thank you, Mr. Chairman. I just wanted to, a couple things. I was trying to get some better understanding. I know you mentioned a little bit about Pennsylvania uses it to some degree, but and Virginia uses it. Tell me about the states that do use what you're doing. How many do we have, and is this DC and especially our neighboring ones? So I wanted to get a sense of that.
I don't know exactly how each state works, but I can tell you that many of the states actually provide it automatically, and Pennsylvania is a state that actually, if you buy $100,000 and you own 3 cars, you get $300,000 because you've paid a premium on each of these vehicles, so that if you were in an accident, you could use it. Other states apply it automatically with no additional premium. All we're asking in Maryland is the most conservative way to approach this is just allow people to pay it and pay the extra cost for it. I could possibly get you, I'll try and get you the list of states that have it and how many states have it. And I'm sorry, Delegate, but I don't have that information now.
Okay,
We'll
that's
try
fine.
and
I
get it
just
to you.
want to understand.
But really, this is the least burdensome on the insurance carriers and the cheapest way to do it.
Delegate, I can't tell you how Pennsylvania does it. In Pennsylvania, it automatically goes on top of the liability for just the premium amount you have. So if you have $100,000, that always goes on top of what the liability had. And then what Bruce was talking about, where each car can have an additional amount, that can be waived. That stacking of the multiple cars can be waived, but the actual stacking on top of the liability cannot be waived.
Okay, and I kind of want to learn what DC does too, but we can get back to that later. Thank you.
I believe that concludes the questions for this panel. We have one more favorable that we'll call up, which is, I believe, Anjamila Gregory.
Anjamila Gregory was a client that I was speaking of. She's unable to be here for the moment. Thank you.
Okay. Outstanding. We'll move the unfavorables. Nancy Egan, Brett Laniger, Marta Harding, Bryson Popham, and enough room. Matt Overturf.
Do you have Robert Ashton?
I do. I just don't think there are enough chairs.
Okay.
However you guys choose to go forward, please introduce yourself for the record and then begin.
Thank you, Mr. Chairman, members of the committee. Bryson Popham appearing before you today in opposition to this legislation on behalf of two clients. One is the Maryland Association of Mutual Insurance Companies, which is a small trade association of mutual insurance companies. Some of them are Maryland domestic companies, and some of them write automobile insurance in Maryland and other states. And also the insurance agents and brokers on whose behalf I've appeared before you before. I want to address just two things. One is the issue that Delegate Queen raised about other states. My client, Mamick, the company, some of them write in Pennsylvania, and they wrote back to me with very, very significant comments about the problems created by the waiver form. I'm the one who wrote the comment in the letter cited by Mr. Garagiola based on their comments. I'll be happy to share the details with you later, Delegate Queen. But I want to focus really on the cost. And forgive me, Mr. Chairman, I didn't bring this with me last year. It is in the bill file from, I didn't bring this with me this year. It's in the bill file from last year. I'll provide it to the committee because you're hearing a lot about the cost of this. The cost is really much higher than has been represented to you. And I have reliable, I believe, rock-solid statistics on that. I have a page that was prepared by an agent from one of my companies. It happens to be the company that represents me. And the cost for this coverage is anywhere from $20 and up per policy per month. It's not $2, it's not $4, it's not $8. It's a lot more than that. And if the proponents are perplexed about why people don't buy it, it's because people act in their own self-interest. They make a decision. They find out what the coverage provides, and they find out what it costs, and then they say, okay, I don't need that. Auto insurance is expensive enough. I think the risk of using this coverage is small. I'm not going to buy it. That's how the decision is made. There's no other reason for it. So with that, I'll cede my time to the rest of my panel. I'll be happy to answer any questions, Mr. Chairman.
I do have a question, sir, because we heard obviously what you would consider a discrepancy in what my vice chair said as far as what he specifically paid. But I guess you would agree that the cost would vary, correct?
Yes, sir.
Okay. And, to be clear, we already do this with PIP, correct?
Well, you do offer PIP coverage. There is an ability to opt out of PIP. I wouldn't say we already do this with PIP.
I should be clear then. There's something that you have to opt out of.
If you don't,
correct. If you would like to save money, like you're suggesting.
That's correct.
And people either choose or they choose to not opt out of PIP, correct?
Yes, sir. They
So
do.
explain the difference then,
Apple and orange, Mr. Chairman, quite simply.
please.
PIP coverage,
I mean, I know what the coverage is. Explain the option, how this option is more confusing than the opting out of PIP.
PIP has been around since 1972. For many years, people wanted to be able to opt out of it. They didn't want it. They didn't need it. They had other coverage.
Sure.
They made their own decision. Finally, the General Assembly permitted a partial, you can't get rid of all of PIP, but you can opt out of it. It is a very small premium item compared to this. The coverage is first-party coverage, so there's no question of liability there. It's completely different. That's why I call it an apple and an orange. If you look at the language in the bill for the affirmative written waiver, it is a recipe for confusion. I can't put it any other way. And that has been the experience of my clients in other states.
And I'm only asking because I read what we're discussing here, and I didn't see the confusion, but I'm also a plaintiff's attorney, so maybe, maybe
Sure,
I'm a little biased.
I understand.
But what I guess I just didn't understand, it seemed very similar as far as when you're talking about the cost. The opportunity is when you go get your insurance, everybody says, "Ooh, how can I save money? Man, that's kind of high." And their agent then goes, "Yeah, well, you don't have to take PIP." Isn't this very similar to that?
As long as the agent, and any good agent will do that, also says you have to evaluate your own risk. What's the likelihood you're going to use this coverage?
Correct.
PIP, everybody can use coverage. You're in an accident, you get your medical expenses paid, you get lost wages paid, no questions. This is quite different. It applies differently. Read the fiscal note. To understand the bill, to understand the coverage, you got to read the fiscal note.
I've read the fiscal note, sir.
And people make, as I said, a judgment in their own interest. And
Right.
they say, I don't think it's going to happen to me.
Isn't that exactly what he's trying to do by allowing them to opt out of it?
To
make a judgment in their own fiscal interest?
That may be what Delegate Crosby is trying to do. I would respectfully submit that if you have to do something, you don't have to do anything, but if you have to do something, you have an administrative agency that works for you. It's called the Insurance Administration. Ask them to put a form together that's in simple English that people can understand. Simple as that.
Thank you.
Yes, sir.
I will. Good afternoon, everyone. My name is Nancy Egan from the American Property Casualty Insurance Association. You may remember me before when I worked for the Maryland Insurance Administration. Just wanted to remind you that my members write 55.7% of all the personal auto here in Maryland. You have a copy of my written testimony, and Delegate Queen, in the footnote of the second page is the list of all states who offer the two types of coverage and explanation of the 5 states that have something that is a sort of a hybrid or no guidance at all. I'd like to direct you all to the Maryland Insurance Administration testimony, which is very, very strong. And what they say is, on the top of page 2, this will result in consumers inadvertently purchasing coverage that they did not want or need with a significant premium increase. And at the bottom of page 2, consumers are best protected by the current law. And they broke it down into 3 parts. The first thing is they did a survey of the 10 companies last year to find out how often the enhanced underinsured motorist coverage is chosen. And they found out it's between 98 and 99% of the time it is not chosen. So the form that the insurance company, the MIA requires disclosures of the different prices for this type of coverage for both the regular underinsured motorists and the enhanced. That means with this bill, 99% of everyone out there will see an increase for a coverage that they did not choose that would be mandated, and then you would have to do a written agreement to remove the coverage from your policy. The second point is in the 3rd paragraph, and if you see, one of the companies did a survey of all their underinsured motorist claims, and they found that whether they had had enhanced coverage, it would not have reached that limit. So it is a coverage that's very, very seldom used. I just would say, everyone, to look at your policies. The best thing to do is raise your limits to the highest that you can afford and protect yourself, and consult with your company or your agent to understand your coverages. Thank you, and I would be happy to take any questions.
Thank you, Mr. Chairman and members of the committee.
Brett Leininger on behalf of Big I Maryland, which is an association of independent insurance agencies, in opposition to the bill. Simply put, EUIM should not be a default coverage. As referenced in the MIA testimony, it only applies, kicks in very rare instances, and therefore shouldn't be the default. If you referenced to PIP before, it does kick in quite a bit and is often used. This does not. Opt-out makes it sound like it's appropriate for everyone. It's just not the case. As producers, we are providing the education so that our clients make informed decisions about what to do. It just shouldn't be the default. Again, default makes it sound like this is something that everybody should get and would be used often. We always educate the consumer about the best coverage, the proper limits, and all of that. And with that, we respectfully ask for an unfavorable report.
Thank you, Brett. I have a question. In Maryland, about what percentage of insurance policyholders actually utilize their insurance, car insurance, on a yearly basis? It's random.
I don't know the answer to that, but
Half? You think half people get in car accidents every year?
I'd be guessing. I really don't.
Panel, does anybody know?
We'd all be guessing, Mr. Chairman.
Well,
I could check and see if we have any of those statistics and get back to you.
because that would be my question. The discussion of, well, it's superfluous because it's seldomly used is what people would also say about having car insurance. Because most folks go through their lives and maybe get in one accident, but we have car insurance for 40, 50, 60 years. So isn't that the same logic you're applying for this specifically?
There's only one other example of a default, and that's PIP, which kicks in frequently when it happens.
No, I was talking about the utilization and how it's seldomly used, so it's not necessary.
Well, it's still offered. I just don't think it should be the default. I think that's the twist here.
Understand. Okay, who's next?
Thank you, Mr. Chairman. Marta Harding here on behalf of State Farm. Not to repeat anything, just in the case of State Farm, 0.5% of applicants opt for this coverage. So it's a very, very small number. The proponents, I think, sort of suggest that the fact that no one is buying it means that it's not being offered. And just to be clear, offering this coverage is mandated by Maryland law. It is in the law right now. We have to offer it to every applicant. And I have the MIA's form right in front of me, and it's in pretty plain English. It says EUM coverage provides the same benefit as UM coverage, but in the event of a claim, the EUIM coverage limit is not reduced by the amount of any available coverage from the at-fault party's insurer. And I think that's pretty much the same language you heard from the proponents of the bill. That's plain English. It's got to be provided to the insured, this form, and they've got to sign off on what they want. They're making an informed decision today. I checked with the Insurance Administration to see if they've gotten any complaints about this coverage not being offered. They've not received a single complaint that this coverage wasn't offered to an applicant. So again, the regulator is the one that is overseeing this, and you have their testimony. I think it's pretty compelling. The last thing I would say, Mr. Chairman, is that the fact that very few people are buying it shouldn't be a surprise, because it is a very, very rarely used coverage, and there is literally because most claims are well below the existing minimum limits, it is almost never triggered. And so and then you heard that from Ms. Egan, that's in the MIA's testimony, that one carrier looked at it and found that it was never used in 100 claims that they reviewed. So for all those reasons, we agree it should continue to be an option, but it should not be the default. Thank you.
And I just want to ask the panel, generally, and anybody can answer this question, because I guess I'm a little confused by the pushback with this. Would this cost you guys more in payouts if this were to go into effect? And when you run the numbers, is that part of the issue? Or is it just a genuine concern for your policyholders that they'll be so confused that they'll end up buying more insurance than they need?
I think it's more the latter. Insurance companies are in the business of pricing risk. And I gave you an example, by the way, in Brandywine near your home, Mr. Chairman, I have an example of a policy that would pay $240 a year. So people act in their own self-interest. The coverage itself is not going to be a money loser or a money maker. It's highly specialized. It occurs rarely, and people make that judgment. They say, I don't think this is going to happen to me. I don't want to spend $100, $200, $300 to buy this coverage because I don't think this particular fact situation is going to apply to me.
And so it sounds like you said they would just say no to it anyway.
Yes, sir.
And so basically, if I understood this, at worst, if this bill were to pass, then their monthly payments in your argument would go up significantly.
Well, it depends on whether they executed the waiver, that very complicated waiver.
If they didn't understand it because it was a very complicated waiver and then they got tricked into getting this insurance, it's my understanding that what you're saying is that their monthly fees would go up significantly.
If they don't have the affirmative written waiver.
Correct.
I believe the insurance company would say to whoever sold the policy, there is no affirmative written waiver here. I'm assuming that panel members correct me if I'm wrong.
Right. And therefore, their insurance policy would be more expensive.
Sure. If you have the coverage, yeah.
And that would go to you guys, the insurance companies.
The premiums would,
And
yes.
that's a problem.
It's a problem because we'd have an unhappy customer. They're getting charged more than they want to pay.
It's not the payout. It's not the concern with the risk of paying out more.
I can say this, Mr. Chairman. I have not heard and I represent insurance companies and agents. I have not heard a single complaint from any of my clients about the payout.
They're not concerned with the payout. They're concerned with the confusion.
They have not expressed that to me.
Okay.
It's the difficulty of administering something like this and the lack of demand.
And that's what I was trying to get to. So I appreciate that. The concern also is the difficulty in administering as far as the individual agents not knowing exactly how to administer it. And
Let me give you an example that was given to there. There are several. This is a common one. You
Please.
have a couple, a husband and wife, and let's say they execute this waiver. Okay, they get divorced. The first named insured on the policy was the former husband. They never make a change to the policy. Later on, an accident takes place, or this issue comes up, and there's no executed waiver on file. Now, this was given to me as an actual example from Pennsylvania, Delegate Queen. The types of things that happen in other states that have this, that's the administrative difficulty that we hear from our carriers who do business in Pennsylvania. That's just one example.
Gotcha. Now, I guess under our Maryland law, you're required to offer it, though, upon
Yes, sir.
only a new policy, though, correct? So my renewal every year, nobody offers it to me because I'm not a new policyholder, correct?
It's only an application,
Yeah,
Mr.
so
Chairman.
if I've had USAA for 25 years, they're never going to offer it to me again unless I switch insurance companies, correct?
You could,
So I would never know about it unless I switched insurance companies.
I think that's accurate.
Thank you. Thank you for the clarity, and thank you for the clarity, sir. Delegate Queen.
Thank you, Mr. Chairman. So just to be clear why I'm asking these questions, because we have a letter from Economic Action Maryland, which is prior Maryland Consumer Rights Coalition, that has an unfavorable. This is the first time in any ECM hearing that you all and they have been on the same side.
Hallelujah.
And so that's making me ask these questions. But I want to read from what they have in their letter. And they say that making enhanced uninsured motorist coverage the default option and requiring consumers to opt out from the EUIM option will result in consumers inadvertently purchasing coverage that they do not want or need. This will increase the cost of auto insurance for all Marylanders, including those who can least afford it. The need to increase coverage for Maryland drivers is unfounded. Maryland has among the highest minimum liability limits in the country, and Maryland drivers carry more insurance than drivers in 45 other states. That's why I'm asking you the data from the other states and asking you why this is needed. I am not an advocate of typically not protecting consumers, so I want an answer as to why this is needed.
May I adopt your testimony as my testimony?
I believe I've exhausted my time with the questions. My colleagues have no further questions.
Oh, you have another witness.
I apologize.
No, you're fine, Mr.
Go ahead,
Chairman.
sir.
I will be brief. My name is Matt Overturf. I'm the Regional Vice President for the National Association of Mutual Insurance Companies. NAMIC respectfully requests an unfavorable report on House Bill 128, excuse me. I will echo the comments that have been said previously and simply leave it at this. We have a shared interest in maintaining an accessible and affordable insurance market that eases the overall cost of insurance for Maryland drivers while maintaining adequate rates. Therefore, NAMIC is concerned that this change will have adversely impact the cost of auto insurance and therefore request an unfavorable report to House Bill 128. Thank you.
Seeing no questions, Delegate Queen. Oh, I see a question there. Delegate Rogers.
Thank you, Mr. Chair. And this is for anyone on the esteemed panel of the Avengers testifying today. Are we going to see a Liberty Mutual commercial about this?
Liberty Mutual is one of my members, and I can find out for you and let you know.
Thank you, Chair. I mean, I'm listening, and I wasn't going to ask, but it's important that I understand what we're talking about here. So I'm familiar with insurance and the term subrogation. So it's when I get into an accident with you, Bryson, and you have the at fault, my insurance company is going to make me whole, but the process behind the scenes is they're subrogating, my insurance company is subrogating to you to make me whole. Is that correct?
Yes, they are subrogated to your rights against me. That's correct.
Okay, so I mean, it's a standard practice to do what we're talking about doing here. Now, the other side of it is the consumer-facing side, which is I'm just a customer. And when I come see you as the insurance agent, I'm like, okay, tell me what you think I should have for coverage. What do I need to protect myself? You might ask me some qualifying questions about your family, your needs, and then I'm going to make a decision, right? Don't you think it's important that you keep that conversation simple to the consumer?
Yes, sir, I do.
Okay. I mean, because every time we have to talk about opt-ins, opt-outs, you're really not having the conversation that you want to have with the consumer, which is, what do I need to do at the end of the day to protect myself in case I need coverage?
Well, if your fundamental question is about the complexity of this coverage and the desire for simplicity, I couldn't agree more. This is difficult to understand, and it is rarely used, as Ms. Harding's testimony, I think, demonstrated.
My point is, as a consumer, I don't even know what the numbers are, but I think that maybe $500,000, I'm throwing a rough number at this. I mean, I'm buying insurance based on what I need, not what I think I can get on top of what I think I need. That's confusing to me. What I want is coverage that says, here are the limits, here's the coverage, and to the insurance company, here's my money every 6 months to pay for that coverage, thank you very much. Any of this other, and it seems conflated to me, because we're sitting as a committee, and I'm literally sitting there thinking, what exactly are we doing here? We did pass this bill a few years ago. The consumer is informed and should be informed, but at the same time, keep it simple, crying out loud. That's my point, and I think that's what I'm hearing in your testimony, that I have to face a customer and help them make good decisions. Is that not so?
Yes, sir.
right,
I think this, yes.
Thank you.
Leave it at that.
I believe I know Dr. No's coming up next, but I believe, and I'll be shocked what his testimony is. But if you guys, I think we've completed
Thank you, Mr. Chairman.
Thank you.
And lastly, we have Dr. or Mr. Robert Enton, who is going to surprise us with some testimony today.
Mr. Chairman, members of the committee, Robert Enton on behalf of the American Property Casualty Insurers Association. I think, you have 2 minutes to speak, and I'm thinking about, sitting here for the last half an hour, 45 minutes, thinking about what points I want to make. And I think the biggest point I want to make is that you really ought to read, I would urge each of you to read the MIA information sheets that you have. They don't have a dog in this hunt. They're not looking to, to make money out of this or lose money out of this. They're the agency that's been around forever. The current ones have been there. Like I said this the other day in the Senate, Robert Barron's probably been there for 25 years, and he's the head of property casualty. But I just would point out a couple things that they say. They say that this coverage is the most expensive and least chosen form of the 3 uninsured motorist coverages available. They say that this will result in consumers inadvertently purchasing coverage that they do not want or need at significant premium increases. This isn't us saying this to you. This is the Insurance Administration saying this to you. When they talk about the cost, they estimate that the cost ranges from 25% to over 123%, resulting in premium increases that could range from $50 to several hundreds of dollars per policy period. Once again, this isn't us saying this. This is the regulator who looks at the policies saying this. I think that to me, it's got nothing to do with PIP, quite frankly. It's $2,500, with all due respect, Mr. Chairman, and it reimburses people for their...
It's my vice chair you're making angry.
Right.
You're good.
Okay. Reimburses people for their lost wages and their medical bills. It just is not necessary. People will not opt out. People will not opt out. We really believe that they don't need this coverage, that it's unnecessary, and if you pass it with opt-out instead of what we have today, opt-in, you might as well just make it a mandated benefit, because that's what's going to happen. So that's why we're opposed. Thank you.
Seeing no questions, Bob, thank you for your testimony. Hopefully my vice chair won't take it personally. Thank you very much, sir.
Thank you so much, Mr. Chairman.
I believe that concludes this hearing. On to bill number 2, which is another wonderful bill by Delegate Stewart. I'm sure this is another non-controversial bill you've got there, young man.
Thank you, Mr. Chair. Mr. Vice Chair, for the record, I'm Delegate Vaughn Stewart. This is House Bill 37. So I got another bad news, good news situation for y'all. So the bad news is y'all still have to deal with me 2 more times after today's hearing. I got 2 more bills. The good news is today's bill is an interesting one, and I actually got it directly from someone who could be our next president, and that's Florida Governor Ron DeSantis. I plagiarized this bill from him. I don't often agree with Governor DeSantis, as you may believe, but on this one we're in agreement because we both hate spam calls, which is the subject of HB 37. So we plagiarized this from Florida. They plagiarized it from Oklahoma, also a state that's not exactly deep blue, and they copied it from about 10 other states that have similar bills. And so, as we know, spam calls are really annoying. The average American gets 3.7 per day. I'm already more than halfway there. I've already had 2 this morning. I don't know about y'all. And more than a third of Americans have reported that they've received a spam call after 10 p.m. before. About 25% of Americans know someone who's the victim of fraud or identity theft, because we also know that sometimes spam calls migrate into the area of scam calls, where they try to get your hard-earned money from you. Robocalls in particular are extremely lucrative for the scam industry. The scam industry, if you can call them that, overall, scammers get about $30 billion a year from robocalls. So that's why you continue to get robocalls from scammers. They're making a lot of money from them. So this bill is pretty straightforward. It has a couple provisions that I'll walk through. You're going to hear from some groups that have some concerns. I've talked to most of them. Senator Kramer, who's the crossfile, and I have had several discussions with folks. We think that we can probably come to an agreement on most of these provisions with the groups that have concerns. So the first thing the bill does is it says before you robocall someone, or before you use what's called an auto dialer, which is an automated system of dialing phone numbers, you've got to get express written consent. Pretty straightforward. We do exempt a number of different entities from that provision. So if you look at the bill, you'll see that we've exempted nonprofits, we've exempted business-to-business sales, we've exempted isolated calls that are done in sort of like not a routine manner. But then regardless of consent and with no exemptions, we also basically make 4 additional prohibitions. Number 1, nobody can call between 8 and 8 p.m. and 8 a.m., period. Number 2, nobody can call more than 3 times. No one group, no one entity can call more than 3 times in 24 hours, which I think is beyond reasonable. Number 3, nobody can use a technology to alter the voice of the caller for reasons of fraud or deception. That's another one I hope that we can all get around. And then finally, we prohibit what's sometimes colloquially called caller ID spoofing, where telemarketers or scammers, whether legal or illegal, use a technology to spoof the caller ID, to basically trick the caller ID into presenting an area code that's not where the person's calling from. They could be calling from overseas, but they're pretending like they're calling from Annapolis, Maryland, or Baltimore City, Maryland. So most of these provisions have no opposition at all from any of the groups. So, for example, nobody disagrees on the timing provision. Nobody disagrees on the voice altering provision. Nobody disagrees on the caller ID spoofing provisions. There are two concerns that the companies that you'll hear from sitting behind me have. One of them, I think, is reasonable. We've heard from a few entities and a few lobbyists that have said, well, if we're calling our own customers with robocalls or with auto dialers and we're trying to provide information to them, that shouldn't be barred. Like if we want to let folks know that there's a fraud alert on their account or their payment's coming up or maybe they've got to renew, we want to be able to do that. That's not spam. That's informational. That's useful. And we agree. Senator Kramer and I agree. We're willing to work with them on that kind of amendment. That's not the kind of thing we're trying to stop. And in fact, I think if you look at the bill text, you'll see that I really don't think the current version of the bill gets to that because the definition of a telemarketing call under existing Maryland law basically means that you've got to be trying to seek business. You've got to be seeking, a new good or service, a new contract, or you're trying to give away a prize, or you're trying to do a survey. There's a specific definition that I don't think applies to informational calls, but we are willing to sort of bend over backwards to make everybody feel comfortable, make everyone feel like we're not touching fraud. I want robocallers. If someone's stolen my account or trying to steal my identity, I want to be notified as quickly and as cheaply as possible. So I'm totally with them on that. The other issue I think that folks have concerns about is the bill's provisions on auto dialers, which are admittedly more strict than federal law, than the federal TCPA statute, which was passed in '91. It does mirror Florida and Oklahoma's provisions, but we define an auto dialer, Governor DeSantis defined an auto dialer, as an automated system for the selection or dialing of telephone numbers. And so basically what happens is these telemarketers, when they call you, not robocalls, but when they're calling you in person, they use these software that dials dozens or hundreds of phone calls all at once. And once someone is sort of dumb enough or unfortunate enough to actually pick up the phone, they connect you with one of the callers in the call center at that point. So the advent of these technologies is why we're even more bombarded with spam calls than ever before. Maryland is actually in the top 10 states that get the most per capita calls and texts. And one of the reasons that folks have been able to pull that off is because of the advent of these new technologies. So we're trying to limit the use of auto dialers to just express written consent. I think you may hear from some people that feel a little bit more warm and fuzzy than I do about auto dialers, but that'll be up to the committee's discretion on which way you go with that. But ultimately, I think this bill is a small step forward, mirrored after several other states, to make life a little bit less annoying for us, and also make sure that a few more seniors and vulnerable Marylanders don't fall victim to some of these scams, and I urge a favorable report. Mr. Vice Chair.
Gone. Delegate Stewart, question for you. Are campaigns excluded underneath this? Just because I know everybody in here has used it.
They are exempted. Political campaigns are exempted. I know. You know, if you want to take that out,
Yeah.
I know. Well, Governor DeSantis did it, and, you know, he's our boy. So we copied Governor DeSantis. They went that way. I think maybe they sent a lot of robocalls in Florida and Oklahoma, so they exempted that. Y'all could go in a different direction. I've never sent one. I'm cool if y'all want to go that different direction, but we do exempt political campaigns.
Okay. And Oklahoma and Florida both passed the bill and it's fully implemented.
Correct. And anecdotally, I don't think there's like a good study, but anecdotally, it's worked. So since Florida passed this 2 years ago, their rate of spam calls has plummeted.
All right. Thank you.
So, Delegate Vaughn, I was thinking about you this morning.
Is that unusual or just another day in the life, I guess?
But more specifically at 9:25 this morning, because I reviewed your bill last night before the hearings, which is, I like to do that. And this morning at 9:25, I got a potential spam call on my cell phone. The cell phone told me this, 443-947-4990, and I didn't answer it. No, it's not. That's the call. Oh, that's his phone.
I think that's Brian Crosby. I think that may be Brian Crosby's phone number.
All right. So the question is, and it's a serious and fair question. Thank you for the fun for a minute. But hasn't the marketplace already solved the spam thing? Because I literally could go through my phone, and maybe we can tomorrow at 9:25 a.m. But you know, I have about 20 of these that I get a week, and I enjoy being able to just ignore it. So the point is, I think the technology is available through companies that know me as a customer that hates them just as much as you, the bill sponsor.
We have made strides. It's a great question. We've made strides, and there have been two basically interventions in the last decade or so that have tried to take a crack at this. And the short answer to your question is they haven't worked because people are still getting these calls all the time. But one of them is what you're referring to, which is the stir-shaken provision, basically invention that was created by, I think people are calling my number a bunch, so maybe the spam callers are getting me. So this is what on cell phones allow people to show when a call is possible spam. And it's not foolproof. It has allowed, when we do receive spam calls and it says spam likely, this is because of this new stir-shaken system, which is nice. I'm able to avoid a lot more calls that way as well. But it's not foolproof. It only catches a fraction of the spam calls, somewhere between 15 to 25%, depending on which state you're in. So it's not foolproof. Hopefully the technology will continue to improve, and that would be great, but it's not foolproof. And then the do not call registry is the other invention that I was talking about. And the do not call registry, I'm on it. It doesn't seem to help very much. But the problem is, number one, robocalls generally exempt from the do not call registry. And number two, it's only law-abiding companies that are compliant with the do not call registry, right? So if you're an overseas scam company doing robocalls, you can just feel free to ignore who is signed up for the do not call registry. So in short, the market is making strides. As technology improves, we're hoping to kind of keep up with them, but we're playing whack-a-mole ultimately. Every time we come up with something new to stop them, they come up with something new to try to continue to spam us.
Okay. Thank you, Mr. Chair.
I'm gonna have to put my phone on silent because I think too many of my either our colleagues or our spam friends are blowing me up right now.
I've called you this entire hearing. Delegate Baffa.
Thank you so much, Mr. Vice Chair. Delegate Stewart, just two questions for clarification.
Sure.
First, in your bill, it mentions, let me pull this up really quick, requiring the prior written express of the called party. How does that functionally work, first off? And secondly, what are the penalties exactly for the party that's making the call? And say we find out, there wasn't any prior written express. How does that actually work?
So there are penalty provisions on that question. Penalty provisions laid out in the bill. I don't remember them off the top of my head, the exact numbers of them. They are sort of additive to federal provisions as well. Right. One I heard over here, there is a huge concern here with enforcement. You know, there are a lot of those overseas companies that are really difficult to find. The FCC has been working really hard to try to expand its net of enforcement to go after bad actors overseas. I'm hoping by enshrining some of these mirror image provisions in state law that our Attorney General will now be emboldened to go after and join some of these state actions. He can join, for example, the Attorney General of Florida, the Attorney General of Oklahoma now, and jointly go after some of these overseas people. But I can't quote to you without the bill in front of me the exact penalty provisions, but how the express written consent would work is actually spelled out in detail in the bill about exactly what we mean by express written consent. But essentially, when you contracted with a company initially, like if you got a good or service from a company, probably in one of their initial disclosures, they would have you, if they plan to auto dial or robocall you, then you would just probably sign up at that point. Or if you're an existing customer of a business now, and they would probably send you an email and say, hey, you know, Delegate Stewart is an asshole. He's making us send this new email, you know, and then you would have to update your, you know, you'd have to update your signature, your authorization with them at that time, basically. But they wouldn't. But it would be written. So I mean, you wouldn't be able to give it over the phone. It's not like they can call you and say, hey, can we consent to robocalling you? You know, it wouldn't work that way.
All right, let's watch language. Did you have another question? All right, Delegate Aarons.
If it's any consolation, I haven't thought about you for days. Okay, just so.
It is a major constellation. I appreciate that.
Thank you very much. After all we've been through, you know, I have actually opted out of something. I get robocalls and texts constantly. Yeah. But some of the problems you have, and it's real hard to defeat these, is when you go onto a site and you agree to something, you inadvertently agree to accept these calls. Mm-hmm. And sometimes they become a nuisance to you. So I'm wondering, and I think there's some legislation, not legislation, some law cases out there right now fighting what you're trying to do with this bill. I agree with it, you know, but I just find it almost impossible to enforce, and I just don't know how you're going to get a grip on it based on what we're trying to do now and what we have now, and how much better or worse it can get. And I will call DeSantis and ask, but I'm not seeing it that way.
Well, Governor Sanders did notch a big win. Someone sued under this bill, sued the governor and sued the state of Florida, and they won. They won a few months ago. So I think that this is going to survive legal challenge. Now, to your question about is this going to be enough, or are we going to solve the problem here, or are people going to be able to avoid it? Well, two things. One, in terms of consent, to your first point, some of these provisions in the bill are regardless of consent. So you can't consent away people calling you at midnight under the bill, for example. They can't just stick some sort of something buried in the fine print of the disclosure and say, hey, by the way, by contracting with us, we can now call you at midnight. That's just straight up not allowed. So the only express written consent part is the auto dialer and the robocall. The rest of the stuff, we're just saying this can't happen. Now, will people still try to do it? Will people still try to break the law? Yeah, people try to break laws that we pass all the time down here in Annapolis. But we still do it. We still pass laws. We still try to stop bad actors. I'm not here claiming this bill is going to be a panacea. I'm not here promising that if we pass this bill this session, that next session this problem will be totally eradicated. But I do think based on what we're hearing in Florida, we can lower that number from 3.7 to something closer to 0. And I think that would be a huge win for our constituents if we were able to do that.
Okay. Did you address text in this bill?
Yes, text are in this.
All right, thanks. I'm good.
Thank you, Mr. Vice Chair. I want to thank you for bringing the bill. I think I'll take half of something over all and nothing. I think you're exactly right. It's not a panacea or a silver bullet. But you know, I have had some people come in and say they have some concerns about, you know, mortgage lenders and those type of things. And did you state earlier, because I had to leave just very quickly, that you were entertaining?
Yeah, we're working with them. We've talked to some of the banks and the financial institutions. I think their concerns revolve around, I mentioned this, but revolve around the idea of robocalling or auto-dialing their own customers with information.
Okay.
And we don't think that's necessarily in the bill anyway, because telemarketing call is defined as like a marketing call, you know, not information. But we have been talking to them. We've been reviewing language. I think Senator Kramer and I are just going to sit down and just hammer out with them exactly what an amendment would look like, but we're more than open to working with them on that.
Thank you. Senator Kramer's good people. Thank you.
He is, I agree.
Thank you, Mr. Vice Chair. Delegate Stewart, good to see you.
Good to see you.
My question is, what was the rationale for exempting nonprofits, and is that what's happening in Florida and Oklahoma? And just want to get a better understanding on that.
Yeah, I mean, the rationale was that I just wanted to blindly follow the governor of Florida. And he did exempt nonprofits. And so he exempted nonprofits, he exempted political institutions, he exempted business-to-business sales. If the committee wanted to take nonprofits out, that's fine with me, but I have heard from a lot of grateful nonprofits that I think maybe sometimes do robocalls or sometimes do auto dialing. I think if we hadn't exempted them, I'd probably be, behind me would be every nonprofit group in Maryland. So up to y'all, but I think they did exempt them, and so we followed their lead.
All right, thank you. I'm looking forward to seeing you in the 2024 ads that I think it's this committee here.
I'm hoping he'll include me. I'm hoping I've done enough here to be included in some of them, yeah.
Thank you, Delegate Stewart. And just so everybody's aware, both Oklahoma and Florida passed unanimous, and everybody was present. So, all right, that is it for Delegate Stewart. Next up, we have Karen Morgan.
Good afternoon, Mr. Vice Chairman, members of the committee. My name is Karen Morgan. I'm here on behalf of AARP Maryland. I'm a member of the Executive Council, and we're here to support House Bill 37. And we're here to support this bill because we're drowning in robocalls. Here's my phone. It knows more about me than I do, probably. It was lovingly picked out. It cost a crap load of money, and it's not a trusted device. I cannot trust this device because when a call comes up, I don't know who's really on the other end because I can't trust caller ID. I can't trust that my contacts are actually going to be accurately filtered. There's not a whole lot I can trust for a device that is this connected to my personal life. We support this bill because it really helps shift the burden of managing robocalls from us normal people to the people and companies that insist on outsourcing basic customer service to automated dialers and robots. It shifts the burden. Finally, under this bill, spammers are the ones who are going to have to worry about whether they have express written permission to actually initiate robocalls, and they're going to be the ones that have to make sure that they're not calling you between 8 p.m. and 8 a.m. This bill also identifies these practices by some of these shady fly-by-night companies for what they really are, which is predatory, unfair, abusive, and deceptive. House Bill 37 would help relieve us from being inundated by robocalls and spam, and trying to manage caller ID is exhausting these days. And at a time when communication with loved ones is more important than ever. AARP Maryland respectfully requests a favorable report on House Bill 37. Thank you very much.
Thank you. Seeing no questions, we will now go to favorable with amendments. We have Brett Leininger and Robert Enton.
Thank you, Mr. Chairman, members of the committee. Robert Enton on behalf of the Maryland Bankers Association, also known as Dr. Yes. And I am signed up favorable with amendments. We've met with Delegate Stewart and with Senator Kramer, who has the cross file. So on behalf of the banking industry, we don't make spam calls to people who aren't our existing customers. And I think we make really what you would necessarily consider a spam call at all. You may get a recorded call from your bank asking you to contact them, particularly in the case where there's been some kind of suspicious activity regarding your bank account. And that can be a recorded call. You may get a recorded call from your bank if you've reached out to them about a product they offer. Perhaps you read about it on a website, you saw an ad for it, and you call a number. You may get a recorded call back from your bank. So the amendments that we've been discussing with the sponsors on this bill would exempt, I think, existing customers from a provider of services or goods informing the customer of information. So I mean, clearly that's going to cover us if there's something that's happened with your account that's suspicious. I think the other thing that was brought to my attention since I talked to the sponsor was we get calls from people who read that in the newspaper, and the response may be, and once again, an automated call. When you look at the definition in the bill, cross-references the Public Utilities article for the definition of a telephone solicitation, and it includes, in order to sell, lease, or rent goods or services, attempt to sell, lease, or rent goods or services. So I think that's fairly limited, but just to be clear about this, we would just like to see amendments which would deal with the situations that I've addressed. And once again, I think the sponsor is amenable to that. So with those amendments, we would say yes to the bill. Thank you.
Thank you, Mr. Chairman and members of the committee. Brett Leininger, on behalf of the Big I Maryland Association of Independent Insurance Agents, in support of the bill with an amendment. As technology has changed and our clients have changed, we have, agencies have more and more, not always, but some have elected to do outreach via telephone or text, automated, in an automated way. The carve-out for business to business is helpful, but seems a bit arbitrary. There's a 3-year threshold. Basically, a business has to be in place for 3 years. That would then not exempt out in a business-to-business setting an insurance agency that is just starting. And that forever, the Big I Maryland is trying to recruit new agents to the business. So our carve-out would be very specific, an insurance producer notifying a current customer who is an individual or business, because we have commercial clients and individual clients, with an active insurance policy placed by the insurance producer pertaining to information about the customer's insurance coverage. So we think that would take care of a very practical way in which more and more of our clients are accepting communication. And we appreciate the opportunity that we've taken to meet with Delegate Stewart's office as well as Senator Kramer. With that, appreciate it.
Thank you. Mr. Renton, quickly, I mean, the bill looks like it's mirrored after Florida and Oklahoma from just quickly Googling. Are there any issues with banks in those states since that bill was passed?
I don't know.
Okay.
We can reach out to the Florida Bankers Association and try to find out. I just think we want to make it clear that if you have an existing customer and there's information, the call could be automated. Once again, the definition of public utilities article is not bad, but we just want to make it clear.
Okay, I think it may be covered under what Delegate Stewart mentioned. It's not solicitation, so I think you may be good, but let's contact the Florida Bankers Association and get back to us.
Absolutely.
Nothing else. All right.
I'm really confident we'll work it out with Delegate Stewart.
All right, thank you both. Now we'll go to the unfavorables. We have Davion Piercy and Rob Garagiola. And once you're up, whenever you're ready.
Good afternoon, Mr. Chairman, members of the committee. For the record, Davion Percy with Percy Public Affairs. I'm here today on behalf of the Maryland Retail Energy Suppliers Association in opposition to House Bill 37. Our members include energy companies like Constellation, Calpine, APG&E, IGS Energy, Vistra, and more. We did submit written testimony, so I won't go into that level of detail, but there are a couple of points that I want to make. Marketing and education through phone calls is a core part of some of our members' business models. They use these calls to educate Marylanders on energy choice and to help them to reduce their utility bills. And though our opposition may seem of peripheral significance, preventing phone calls will significantly hamper, our members believe they will significantly hamper their ability to promote energy choice in Maryland. So with that, we urge an unfavorable report, and I would like to refer to my written testimony for more information. Thank you.
All right. Rob Garagel with Compass Advocacy here on behalf of CTIA, the National Trade Association of Wireless Communication Industry, an unfavorable for House Bill 37. Provided written testimony as well and also provided it to Delegate Stewart. I actually thought about Delegate Stewart at 11:15 today because I got an unwanted text message, but I actually had the option to type in stop. And I got a response back that I'm going to be off that list. And what I would say about the wireless communications industry, and I think Delegate Adams touched on it, they put a lot of energy and effort into a number of protocols to work to prevent, whether it's the phone calls or the text messages. Delegate Stewart mentioned the stir shaken. That's something that's come about in recent years as well. The wireless communications industry has been working with the FCC, the FTC, the Department of Justice, as well as 51 attorneys general throughout the country, including in Maryland, to combat this. They don't want unwanted spam, whether it's phone or text either. No one does, frankly. But we do believe that the bill can have some unintended consequences with respect to some of the things that you heard earlier from the bankers and the insurance and retail suppliers, as well as others. I get text messages and calls from my pharmacist, from my barber, other businesses as well. And so I think if we proceed with this legislation, we do need to be very careful with the definitions and how we work through it. And so I've expressed to Senator Kramer on the Senate side, and I've expressed to Delegate Stewart, we're happy to sit down with him and kind of work on some of this language, but at present we're unfavorable.
Thank you. I just wanted to, I guess, we talked a lot about the technology and how it's changed, and many people are using wireless. They're using their cell phones to conduct almost all of their business. But there's still a core piece of the population that have landlines. And so getting these spam calls, many people maybe only use it just in case of an emergency. And so to have the spam calls coming in can still be a burden to them. Isn't that so?
Absolutely. I mean, unwanted spam calls are intrusive and are a burden to anyone who gets them.
Okay, seeing no other questions, that concludes this bill's hearing. And next we'll go to House Bill 62, Delegate Charkoudian, Land Use Public Service Companies Pollinator-Friendly Vegetation Management.
Thank you. Mr. Chair, can I bring up my panel?
Yep, and then start when ready.
Thank you. Vice Chair Crosby, colleagues, what a thrill to see you from this side this session. For the record, Delegate Lorig Charkoudian here asking for a favorable report on House Bill 62. This bill is about pollinators and protecting pollinators, but before I tell you what the bill does, I want to make sure I tell you what the bill doesn't do. The bill does not require utilities to do anything. And that's really important because as I walk through what the bill does, if you're looking at some of the testimony, the opposition testimony, as well as some of the letters that came in, there's a reference to this would require utilities to XYZ. And so it actually doesn't require utilities to do anything. But it gives utilities an option to be part of the movement that is about protecting pollinator habitats. And so what you'll see in the state, we've done a lot of work on the sides of roads and SHA's management and wildlife management and supporting residents. A lot of this stuff comes in ENT, but they've done a lot of work with homeowners associations and condo associations to really support the voluntary creation of pollinator habitats. And why do we want to do that? Well, we know that pollinators are in danger, and we know that we need pollinators to survive, right? Like our food depends on having healthy pollinator habitats. So that's a pretty core thing. So then when we look at how do we create pollinator habitats and ways for pollinators to essentially travel through in their migration all the different parts of our state as they're going from here to wherever else they're going, and different pollinators and different wildlife have different life cycles and different traveling patterns. But the more areas that we have, again, voluntarily maintained, that are pollinator friendly, the more our pollinators can survive, thrive, and do their work that gives us food to eat. Really important. So what we did was we took a look at the areas that are under power lines, and this is an area where there's an opportunity to build pollinator-friendly habitats. And in fact, the utilities already, BG&E and Pepco, I've had multiple conversations with them, are doing some really good work in different parts of the state building these pollinator-friendly habitats. And so when we look at what are the barriers that might be there from doing even more pollinator-friendly habitats under these power lines, one of the barriers that came up was counties' ordinances that are related to weed heights. And so what we essentially did was we created a legislation that says, if an area is being maintained as a pollinator-friendly habitat, and we define what that is, then the weed height ordinances can't be applied to require that they be cut down, with the exception of human health, safety of power lines, or agricultural land, or trails. So while this doesn't require the utilities to do anything, it does allow utilities who already are and want to do more in the way of building pollinator-friendly habitats under the power line corridors. So that's the crux of what this bill does. And the hope is that as it's successful, as we pass it, the utilities will choose to do this more and more. We have had a number of conversations with the utilities because even though it doesn't require them to do anything, we do hope that the way we structure it will incentivize them to create more pollinator-friendly habitats. And so we have worked with them on some language to both maintain the scientific necessities for pollinator-friendly habitats and maximize the likelihood that they would take advantage of this opportunity. We also have worked with native plant experts, some of whom you'll hear from shortly. And so there are amendments coming, and I think some of the concerns that are addressed in some of the comments that you received, we have amendments that address them. But I think there'll be an amended set of amendments coming shortly. And I think with that, I'd like to turn it over to folks who have expertise in these habitats, and then we'll all take questions.
Great. Good afternoon, Chair Wilson and committee members. My name is Michael Wilpers. I'm testifying on behalf of the Sierra Club Maryland chapter and its 70,000 members and supporters statewide. We strongly support HB 62 because it can help reverse the statewide decline in habitat for pollinators, such as bees and butterflies, by reducing the amount of mowing along 2,000 miles of electric transmission lines in Maryland. The resulting increase in meadow and grassland habitats will support more of the insects and birds that pollinate our vegetables and fruit crops, wildflowers in natural areas, and other plants throughout the state, including your gardens. Across North America, nearly a third of all bumblebee species and 20% of our butterflies are threatened with extinction. For this reason, Maryland's Pollinator Protection Act of 2016 required two of our largest state agencies, the DNR and State Highway Administration, to greatly increase the amount of pollinator-friendly habitat on their lands. At the same time, as you've heard, Maryland's utilities have shown that power line corridors can play an important role in supporting pollinator communities, but so far almost entirely on federal, state, and county parklands in Anne Arundel, Prince George's, and Calvert counties especially, and other parts of the state as well. Our utilities could significantly expand on these successes if not for the many county weed ordinances originally intended for homeowners that require wildflowers and grasses to be kept at no more than 12 inches in height. HB 62 removes this barrier by exempting electric utilities in areas that they decide to treat as pollinator-friendly habitat. Importantly, this bill preserves the authority of utilities to mow frequently wherever needed to ensure the safe and reliable delivery of electricity, and for the counties to impose their weed ordinances wherever necessary to protect human health and safety. In sum, the bill offers a genuine win-win solution benefiting the environment through the expansion of pollinator habitat while enabling the utilities to reduce unnecessary expenses. For these reasons, the Maryland chapter of the Sierra Club urges the committee to support this bill, and we recommend its passage to the General Assembly.
Can you just move here for the...
Good afternoon. Judy Fulton speaking on behalf of the Maryland Native Plant Society. We support House Bill 62 with the delegates' changes because of its importance to native species. We're a nonprofit with over 2,000 very active members making a difference in Maryland for 30 years. Frequent mowing decimates native plant populations and allows low-growing non-natives to take over under power lines. These non-natives create an environment that looks lush but is functionally a biological desert for native pollinators, birds, and other wildlife who cannot survive without the plants they evolved alongside. Not only do the non-native plants damage the environment, but they cause harm to human health and cost the U.S. over $34 billion every year. 1/3 of the U.S.'s plant species may go extinct. By creating power line corridors for native plants, we can help preserve biodiversity and give Maryland's most endangered plants a chance. Our beautiful blue sundial lupines are at high risk for extinction, along with the globally rare frosted elfin butterfly, which can only survive on lupines. And I've seen these lovely lupines blooming where BGE and Pepco reduced mowing. Frequent mowing destroys native flowers before they can produce fruits and seeds. How can there be genetically diverse plant populations that can deal with disease and the hardships of climate change if new plants can't grow? Healthy habitats require a lot of biodiversity to sustain themselves, but over 40% of U.S. ecosystems are at risk of collapse. The good news is that botanists have counted over 125 native plant species in a rarely mown quarter mile of the power line through the Sligo Creek area. With Pepco's careful vegetation management in Montgomery County's Travellas serpentine, a globally rare type of ecosystem, there is hope for other critically endangered plants, including striped gentian and featherbells. Let's do our part and preserve Maryland's natural heritage for future generations. The Maryland Native Plant Society urges a favorable report on HB 62. Thank you.
Thank you, Mr. Vice Chair. I heard you say that it doesn't require utilities to do anything, but I wonder if you could clarify your definitions a little bit when you talk about the pollinator-friendly vegetation management. For instance, it says mowing not more than once per year and only during February or March. That's kind of unrealistic in some of the more western parts of the state where there's several feet of snow still on the ground. So could you just explain how that definition works in with the requirements of this bill? And then some of the language seems somewhat subjective. It talks about judicious use of herbicides. I don't know if that term's defined.
Yeah, sure. So first, if we passed this bill, nobody would have to do anything differently. So that is important to know. Now, I'm happy to explain what is in the bill and answer your question. But if we were to pass this bill as is today, which we're not going to do because I have a bunch of amendments for it, still nobody would have to do anything different than what it is that they're doing right now. So that's just a really important point.
I got that.
Okay. So in terms of the mowing, we actually have changed the amendments that I have, change it a little bit to November to March, mowing every other year, but only between November and March. And then in the Appalachian Plateau or the Ridge Valley Province, which is Western Maryland, October through April 30th. So because basically the species life cycle is different in that part of the state, mowing in a different time period is less likely to wipe out early, eggs of a species as it would if it were in this part of the state, if that makes sense. So we've done some work, and I actually sent this to Potomac Edison earlier this week, and I haven't heard back if it addresses some of their concerns, if that's what you're looking at. You had there was a second part to your question. What was
I guess
that?
maybe the subjective definition of some of the terms like judicious use. I'm not sure what that means.
Yeah, so that's the use of pesticides, I think, that's that section.
Yeah,
So that's been
herbicides.
changed to talk, and again, I'm sorry that you don't have, this is sort of in my notes, but integrated vegetation management, and it describes what that is. So I agree that it was originally kind of broad language, and so we're working on refining that language as well.
Okay, thank you.
Delegate Queen.
Thank you, Mr. Chair. My question more is trying to understand some of the bill intent. Well, I think I understand the bill intent, but who has jurisdiction? So currently, if I'm understanding, these vegetation plans are happening on federal and state lands, right? And so now we're looking to say wherever we have power lines, which could be county, state, or I don't know of any federal in my area, but
There's some that's like Fish and Wildlife.
okay, so there could be all three. So then what happens there? Because it might be county ordinance we'd have to deal with. So how is that addressed?
It is county ordinance that this bill addresses. That's the specific
So we're
thing
saying
this is.
the county is we're gonna ask the county to follow these rules. Because we haven't had any weigh-in from any county people. That's why I was looking at your testimony. So
So I reached out to Mako and I ran this by them and they made some suggestions and then they're neutral on it because I incorporated their suggestions in the original bill.
Oh, okay.
But what it does is it's still the utilities. So right now, utilities are responsible for maintaining the right-of-way under the power lines. And so they can do it in any number of ways. But because there's county land that they're on, the county can say to them, you have to keep it below 12 inches, right? Because that's our weed ordinance. So now, if this bill passes with the amendments, if PEPCO were to say, we want to work with Friends of Sligo Creek and we want to establish this area to be pollinator friendly, they identify it, this is the area, they follow the specific guidelines here. Now they're exempt from Montgomery County's or Prince George's County's weed height ordinances because they're managing it, not just because they're letting go willy-nilly, but they're actually managing it as a pollinator-friendly area. And it's only that part that's exempt. So if there's another part that they're just not taking care of, and the pollinator-friendly area is over here, they can still be expected to take care of that other part over there that just has high grass that needs to be mowed. But whatever they're managing within the context of the definition, and this is part of why, even though the definition is being adjusted to some extent, we still want a tight definition. We don't want to say like, hey, if you think you're doing something that's good for pollinators, then you don't have to follow anyone's rules. We want a pretty tight definition and say, and if you're doing all these things that we know are good for pollinators, then we're going to ask the counties to exempt you from these rules that would otherwise be in place.
Okay, so the utilities would go and ask to have this exemption to the counties.
Well, I don't think they have to go and ask. They would just essentially, if the counties came and said, cut that down, they would point to their management plan.
Okay.
Right.
And so what happens to those people in the community where one part's being done this way and one part's doing that? How is that addressed? And that's why I want to hear from the county, I guess, and how they feel that they could manage that. Because I could see a lot of phone calls coming in with what happened, why haven't you, get them now, why hasn't this been cut down, why hasn't this happened? So how is that going to kind of, can you manage that management for me? How's that going to happen?
Yeah. Well, I think that it is, I think like one of the things that we've learned is that there's a lot more learning that we have to do of our community members. Like if we're going to have a shot at survival, there's a lot that we're going to have to do differently. And so we try to have, make these changes in a way that's least uncomfortable for the most amount of people. But ultimately, if we want pollinators to pollinate our food, we need to be doing something that gets us pollinators. And if that also gets us a few folks calling us, then it's an opportunity to educate them. And I will say some of the areas that I think the utilities have done well, they actually use it as an opportunity to educate. So like as you're walking by on, whatever the pathway is, there's a sign that explains what's happening there and why that's important, why that kind of management is important.
I could add something, Lauren?
I think they usually want just one answer, unless.
Delegate Ernst.
Thank you, Mr. Chair. When you talk about this, the utilities, is there any conversation about maintenance on these lines and catastrophic failures? If they can't get to them because of growth?
Yeah, so the rules, the public utility laws already require that they have the ability to access the lines. And this bill includes explicitly, again, although it's just redundant to put it in here, that the ability to maintain the lines is an exception to any other pollinator-friendly things that they might be doing.
So if there's some egregious weed, they could take care of something that's growing too fast or too far and getting up too high. prevent that.
That's exactly right.
The other thing, you know, this brought up something, I was wondering if you had any consideration. When we talk about pollination and all that, what are we doing in solar fields? Is there any of this that can apply to a solar field?
Yeah, actually, one of the things that works really well together is solar panels and pollinators, and we've already passed legislation in this state that requires that solar fields be pollinator friendly. Pollinators do really well around solar plants, they can grow under and around them. So we already have rules in the state, I think from like maybe 2017, that require pollinator friendly habitats around solar.
It also is animal friendly, right? We're talking about the habitat for wildlife and whatever, right? Okay, with fences, is there any consideration about all the fences surrounding the solar panels?
So this bill doesn't talk about solar panels. So
I know, but we're making it pollinator and wildlife friendly is what the intent is, so the wildlife can flourish.
But this bill doesn't change any rules on solar panels, just to be clear.
Thank you.
Delegate Harrison.
Thank you. As I understand the intent of the bill, and certainly, you know, playing around with gardens and all of that, I understand the need for the pollinators. My concern or question, as we, if we to pass this and these, around these transmission lines or transmission fields, and one, you know, there's some reason that the utility company needs to get in there to do some work, and what may be growing underneath. So we've got the birds and the bees and the butterflies up top, but if we underneath we may have the snakes and everything else. And so, and in some of these fields, I know in Prince George's County, abut residential communities. And so, if there are things that are growing underneath, and they may decide they want to go visit the neighbors. How do we deal with that? Now, would they be there? I don't know. I just think about high grass, high vegetation, and the very real possibility of that.
So the exceptions in the bill, that's in the current bill, actually not, it won't, like, it'll also be in the amendments, but it's in there already, is that the jurisdiction is not prohibited from enforcing their weed rules for the safe and dependable delivery of energy or human health or safety. So if there were actually a human health or safety concern, then the utility could be asked to, you know, cut down the plants that are there, right? Like snakes or whatever else.
But the human health and safety concern could be one of the workers who may have to go in and do whatever needs to happen, and then they unfortunately have a encounter.
So I know I've said this a few times, but I want to back up and make sure it's clear that the utilities are not going to voluntarily put a pollinator-friendly habitat together that puts their workers in danger, right? Like their number one priority is maintaining those lines and making sure that they're running safely, and that includes workers being able to get to them. So when they make decisions about where they could possibly put a pollinator-friendly habitat, if there's a concern about that there may be some snake that would bite someone who's trying to get to fix a pole or something, I think that that's not something that they would put there, right? They're choosing where they want to put the pollinator-friendly habitats and where they don't want to put the pollinator-friendly habitats. Does that make sense?
I guess I've never been through a transmission field. I only see them from the roadway, so I don't know how close they are, the line, the poles or the towers to one another. So if they put one in the middle, then it wouldn't necessarily be right around the tower and they could get to it, perhaps. But I am concerned about particularly where I can think of two communities right off the top of my head where the lines, you know, just go, you know, they traverse the you know, miles and miles and miles, and they just cut through communities, but they're right up in some places right up adjacent to residential communities, and I would be concerned about that. But okay, thank you.
Laura,
Thank
do you mind if I?
All right, thank you. That concludes the favorable panel. We'll now go to favorable with amendments. I have one in person, which is Drew Schmidt Perkins, and then we'll follow up with the virtual, which is Jim Brown.
I think that I heard that Drew is stuck in the Senate. That was the
Okay.
text that I got earlier.
So we'll go virtual. Is Mr. Brown is in there. So Mr. Brown, once you come up, if you can hear me, if you can go, yep, you're off mute. Go ahead and start when you're ready.
Great, thanks. Thank you for having me, committee. It's good to see everybody. My name is Jim Brown. I'm the policy director for Audubon Mid-Atlantic here in Maryland. Audubon Mid-Atlantic is the regional office of the National Audubon Society, representing over 35,000 Marylanders who advocate for the protection of birds, bird habitat, and policies, aiming to protect both birds and human communities in the face of increasing environmental challenges, habitat loss, pollution, and climate change. Audubon Mid-Atlantic enthusiastically supports HB 62 with, with Delegate Charkoudian's amendments. This bill protects birds. What is good for pollinators is good for birds, and what is good for birds is good for all of us. Science tells us that birds are in decline due to habitat loss and fragmentation. 1/3 of eastern forest species experienced significant population decline in the last 50 years. Grassland and shrubland birds are disappearing even faster. Utility corridors offer us a solution. These species require meadow and shrub conditions that HB 62 will provide, enabling edge meadows and critical landscape diversity for birds to nest, rest, breed, and feed. Iconic birds such as the wood thrush, brown thrasher, prairie warbler, eastern meadowlark, and blue grosbeak, which are in decline across Maryland, will benefit from this bill. We've seen this proven to be true here in Maryland, in Anne Arundel County, on a BGE power line that is managed as habitat by the U.S. Fish and Wildlife Service. Over 120 bird species use that corridor that crosses the South River Greenway, including the declining field sparrow, prairie warbler, and yellow-breasted chat. In closing, the science tells us that Maryland habitat is increasingly fragmented. Fragmentation leads to declining bird populations. Voluntarily restoring power line right-of-ways to a more natural state will increase bird habitat and maintain the integrity of the utility grid. We respectfully urge a favorable report of this legislation, keeping Maryland a leader in habitat conservation and ecosystem preservation for the protection of birds now and into the future. Thank you.
Thank you. And seeing no questions, that concludes this bill hearing. We have one bill, the final bill for today, and one bill remaining. The final bill for today is House Bill 68, and it's Delegate Corman. It's electricity net energy metering, accrual of net excess generation.
Thank you, Mr. Chairman, colleagues in the Economic Matters Committee. I'm Mark Corman, presenting the Net Metering Flexibility Act, HB 68. This committee well knows what net metering is. If you have solar panels on your home, you know, those electrons go into the grid. You use some for your house, but there might be excess. Not at my house. We are unfortunately using more than our solar panels are generating. But for some people, they're actually sort of setting the surplus into the grid, and that process is called net metering. The way it works in Maryland is you basically accrue and use credits beginning in April, and it goes 1 year, and then at the end of that year, you get cashed out. If you have any sort of excess generation, you get cashed out. We have a 3,000 megawatt cap in Maryland for net metering. We're about a third of the way there, so we've got a long way to go to actually meet our I wouldn't even call it a goal, but our cap for net metering. So I was going door to door last year, as many of you were, and met a constituent who said, why am I cashing out in April when my heaviest energy usage months, as they are for many of us, are during the summer? And so I spent a little bit of time looking at it with my staff and realized that other states were doing it a little bit differently. And there are ways to make the net metering more consumer friendly and maybe incentivize it further. And so come before you with this bill that would do two things. One, it would move the fixed date to August, but would also give an option for folks to just roll over their credits continuously. And so they would continue to be able to draw down from those as they have energy usage in future years. I will just say, you know, there's a lot of amendments and thoughts flying around. There's a lot of testimony, and I know advocates have been going door to door about it. So there might be slightly better ways to do this, but the overall goal here is to make net metering both more consumer friendly and also incentivize its use, get more people to take part in our slow but necessary deployment of these. So if the committee is interested, look forward to working with you to fine tune the details. But that's the goal here, and that's the legislation, Mr. Chairman.
Yes, good afternoon, Vice Chair Crosby and members of the committee. David Lapp here on behalf of the Maryland Office of People's Counsel in support of House Bill 68 for its added customer flexibility for net metering options. I'll be brief and make 3 quick points. The first is that distributed energy resources are important for customers as the state transitions to meet its greenhouse gas reduction goals. Rooftop and community solar are important distributed energy technologies. They potentially lessen the need for costly distribution system enhancements, increase the distribution system's resilience, its ability to handle adverse weather events, and they lower carbon emissions. The state needs to think creatively about ways to make DERs more consumer-friendly, and this is one of them. Second, the option added by the bill sends important price signals to customers considering installing rooftop solar or subscribing to community solar who are thinking of electrifying in future years as they replace their household heating and cooling appliance like space and water and heating and electric stoves. Also, customers who are considering electric vehicles in the future. They can acquire more solar now and bank the credits for later when their electricity usage increases. Third, overall, while this adds great flexibility for customers, helpful flexibility, the effect on overall rate should be negligible or even beneficial. Finally, I just wanted to note that we understand that an amendment will be offered so that once a customer chooses the option of carrying over the credits longer than a year, the customer can't then switch back to cash in on excess generation at the commodity rate and game the system. Our written testimony expands on my oral testimony. I appreciate the opportunity to be here today. We ask the committee for a favorable report. Thank you.
Thank you, Mr. Chair. So to the sponsor, there's an amendment I think I have in my packet here that changes the word metering and inserts the phrase virtual net energy metering. So I know what that means. I'd like to hear what you think.
Yeah, I think there's, as I said, a number of amendments floating around. Some of them are just to make sure that we are getting at the full range of options that this committee and then the full House and Senate following your lead have made available over the years to make sure we're capturing the full span of solar options, including community solar and other options like that. So that's the point of that, suggested amendment.
Well, I mean, the follow-up to that is energy is anything but virtual. I mean, it's consumable. It's also, unless there's battery technology to save it, it's all theoretical, this concept of saving and reserving these net metering balances for future use. And I'm just curious, as the sponsor of the bill, how do you reconcile someone saving money on their net metering? And you're shaking your head, so maybe I have it wrong, but no, I'm assuming net metering is your solar system's creating more energy than you're consuming, ergo that difference stays with you over time and then you get to use it later. I mean, that's just not how energy works. I'm just asking, conceptually, how are you reconciling demand and usage in the system globally versus someone being able to bank up savings? So maybe they go on vacation for a couple weeks and don't use energy, and then all of a sudden they come back in a hot summer afternoon, now they're using energy coming back through. That's the question.
Yeah, no, it's a great question, Delegate. I think what happens is the utility uses the energy that's being generated. So if I'm not using it at my house, that energy is going into the grid and being used. It is helpful to the overall grid, and that is energy that then they don't need to buy from somewhere else. They're getting it from the solar panels on the consumer's roof. And so the reason for the accrued credits is because the utility is using that energy to power someone else's house and being paid for that. And that's why they then pay, and I'm just using me as an example, Delegate, me as the generator, because I'm the one who had the solar panels installed on my roof. So yeah, it's not that I'm getting paid for power that wasn't used. The power is being used. It's just not being used by me personally. It's going back into the utility.
I guess let me rephrase, because what I'm saying is when you're generating excess capacity because you've got a little power plant on top of your house. I get the concept. I'm saying that there are times where that savings or that value, I think you're implying that you should be able to save that for a period of time, and I think they say maybe an indefinite period of time, that now I get to use that value at a later point. And I guess I'm trying to understand.
So that's already true, Delegate. You already get it basically for a year that it's saved up. At the end of that year, currently, under current law, Delegate, you receive a check if there's an excess remaining. This just creates some more flexibility of that process, the timing of when you might get that check, or if you just continue carrying it over longer than that 1 year. But that concept of carrying over the excess and being compensated for it, that's existing law.
Okay. Thank you.
Account is closed. Because are you talking about the overall electric account, or because you can negotiate obviously your generation, so you may end up negotiating with a different supplier, and that account is closed, but you still have the same overall electric account.
Right. The account is with the utility. The utility doesn't change even if your supplier changes. You still, in my case, I use Pepco. Forgive me, Delegate Weibel, I'm not sure who your provider is. A lot of us in this room probably have BG&E. That utility, which whoever I choose, if I go into the retail market and don't use standard offer service, the delivery is still through the utility
You're talking
that
about
owns
the
power
distribution
lines.
account, not,
Yep.
okay. And then, and I don't know how utilities work, but if someone gets married, divorced, whatever, is that account closed even though that person may still be staying in that same residence, or do they just change the name on the account?
So you don't know how utilities work, and I don't know how divorce works, thankfully, so I actually can't, I can't.
I can talk to you about that sometime.
No comment, Delegate. I'm not quite sure how that would work. I imagine there are ways to maintain an account with making name changes and things, but I'm honestly not sure.
Thank you.
All right, seeing no other questions, that concludes this panel. I have one final witness. It's favorable with amendments, John Fiastro.
Good afternoon, Mr. Vice Chair, members of Economic Matters. For the record, my name is John Fiastro on behalf of Arcadia. Arcadia is a subscriber coordinator here in Maryland and also nationwide. Arcadia has 100,000 community solar customers, and here in Maryland, they manage subscriptions for 54 projects totaling 84 megawatts of distributed energy resources solar. Arcadia comes today with favorable testimony, asks this committee to move favorable on the bill with an amendment that you'll find in Arcadia's testimony. The amendment provides the same treatment towards community solar as well. Delegate Corman alluded to it. Arcadia prides itself on guaranteeing savings for customers across the board. And if you are a Arcadia customer, if you look on your Arcadia customer dashboard online, you'll find the rolling savings for the year, for the month, and for the life of your relationship with Arcadia. So the current net metering construct can lead to a confusing customer experience for a community solar subscriber. When that community solar subscriber enjoys a monthly savings, they go about paying their bill and they're enjoying 5, 10, 15% monthly reduced rates as to what they would be paying if they were on regular service without their subscription. So at the end of the year, a customer might get a check for $4 or $5, and that can be confusing because they've thought they've been enjoying savings, and then they get this $4 check, and then they call either Arcadia or their wires utility, and they say, you know, what's this $4 check for? I thought it was saving significant dollars. Well, they have been, but this check is a little confusing. It's not. That's not true. It's not the totality of their savings. It's what they've been enjoying. Their savings are what they've been enjoying on a monthly basis throughout the course of the year. So the amendment allows for the rolling credit for community solar customers. It would provide for an enhanced customer experience. And with that, Mr. Chairman, thank you, and that concludes my testimony.
Thank you, and seeing no questions, that concludes the bill hearings for today. I hope everybody... What? Who? Oh, I apologize. Hold up. My bad. We have two informational in person. We have Brett Sproul and Lisa Smith from the PSC. My bad. When ready.
Raise, Mr. Chair. Thank you for having us. We'll be very brief. Lisa Smith, Director of Legislative Affairs for the Maryland Public Service Commission. I'm here primarily for questions. I'm accompanied by my colleague, Brett Sproul, who has much more technical knowledge than I do, and we just want to be responsive to Chair Wilson's request that we come more often and provide information. So that's what we're here for. If you have any questions, we'll be happy to answer.
Great. Good afternoon, Chairman and committee members. My name is Brett Sproul, and I am a technical advisor for the Maryland Public Service Commission. I'm here today to provide brief commentary and answer any questions related to House Bill 68, otherwise known as the Net Metering Flexibility Act. This bill has two main changes to address. Number one, changing the billing or cash out date from April to August. And number two, allowing a customer to accrue net excess generation indefinitely into the future. First, changing the billing date from April to August could reduce overall benefits for net metering customers. For net metering customers, banked or accrued excess generation reduces the entire customer's bill, both distribution and supply. In contrast, cashing out net metering generation pays the customer the dollar value for only the supply portion. The current scenario minimizes a customer's cash out amount in April, thereby maximizing the overall value of the customer's net metering benefit. If the billing or cash out date changes to August, a customer could receive a higher payout but ultimately less benefit. This change has the potential to benefit some customers at the expense of others. Second, allowing customers to accrue net excess generation indefinitely could potentially increase the overall compensation that goes to net metering customers. A net metering customer is only required to pay a small customer charge for their utility bill and not other portions of their bill when they have excess net generation for any given month. Indefinite accrual of net generation could increase non-net metering customers' bills because utility rates need to collect the full cost of their system regardless of usage. Finally, I will also note, as mentioned in PEPCO's informational letter, any utility IT or billing system changes will have costs borne by all ratepayers in Maryland. There are a few other minor concerns that we have been working with the sponsor and staff to address, but I'll yield my time to answer any questions. Thank you for allowing me this time to speak.
All right, thank you. And seeing no questions, now that concludes this bill hearing. My apologies,
Thank
didn't
you.
mean
Thank you.
anything
Thank you.
personal. So that concludes the bill hearings for today. I hope everyone enjoys their afternoon. See you tomorrow.